the Constitutional Court of the Republic of Indonesia will hold the third Indonesian Constitutional Court International Symposium. This symposium aims to provide an international academic forum to discuss various constitutional issues. The Constitutional Court of the Republic of Indonesia provides an opportunity for academics, researchers, and international scholars to participate in this international symposium.
About a very, more interesting topic about conventionalism's adjudications in Colombia. The floor is yours, Mr. President.
Assalamualaikum. It is an honor for me to be here in such an important academic scenario with such a distinguished group of scholars and friends. It is tremendously inspiring to see how in such a distant country from my own, the interest in the role of the judiciary in the protection of democracy and human rights are the same. My father himself was a judge, so for me it's very inspiring to see all of this. Is the whole reason why I'm here. The theme of this presentation is the conventionalization of judicial adjudication in Colombia. And when we talk about this, I'm referring to the growing influence that the American Convention of Human Rights has in the decisions of the high courts of my country. Of course, this phenomenon belongs to the wider process of internationalization of constitutional law, you could even say the globalization, the movements of people. This is the new thing for humankind. And I refer to the judicial aspect of constitutionalization of law, of the internationalization of constitutional law, because it's the judiciary where both international agreements and constitution have come to be a reality and not just an ideal. The international law has a promising future in Colombian constitutionalism due to the advanced level of constitutionalization that my country has and due to a long tradition of judicial power, of judicial independence. The Colombian judiciary for many years have been the sole defender of human rights and democracy in my country, and this can be seen because the courts have been victims to the most vicious attacks, both by political powers but also by armed actors. Needless to remind that in the year 1985, the Justice Palace was taken down by both guerrilla members and military members, and this is of course a sign of how many bad people is unhappy by the work of the court. Also, the powers of the court can be visible in the decisions. As most of you know, the Constitutional Court of Colombia has applied the institution of the unconstitutional constitutional amendments, but moreover it has made many, and it made it in a very controversial case, that is the third period of the election of President Uribe. If it wasn't for that decision, we would have, as the current president calls him, the eternal president. So it was a very major, very important decision. Moreover, our version of the amparo that has been mentioned several times, our amparo is called the tutela, and is much more ambitious than the Spanish amparo. We have, the Constitutional Court has applied the institution of the intercommunis decision, which means that due to the large number of tutela that has come to the court has begun to emit decisions for similar cases. So in just a single decision ends up affecting many people, inter pares. Not inter partes, which is the two, but inter equal people. So, for example, in the case of the people that is in jail, they have come to the court several times asking to be protected their fundamental rights because there's too many people in jails. The jails have not the facilities to take so many people. So there's let's say 200%. It is overrun, the carceral system of my country. So many people came to the court that at the end the court said, listen, we cannot keep deciding case by case. So we ordered the government and the legislative to implement a public policy to fix this problem. It did the same with the people victim of forced displacement. In Colombia, we had around 6 million people that were taken away from their homes or kicked away from their house by the conflict, and they were in our cities, in our big cities, unattended. So the court, at the end, due to all of these tutela actions, it said, listen, government, Congress, you have to legislate on this matter. The same with the LGBT communities. The Congress would not say whether gay couples could marry or not. So at the end, the court said, Parliament, you have 5 years. If you don't do anything in 5 years, it's going to be like this. The Parliament didn't do anything, so it had to be what the court said. So the gay community, the LGBT community can have their rights protected due to the Constitutional Court. So what I'm trying to say is that the Constitutional Court has a very affirmed authority, but not only the Constitutional Court, but also our Supreme Court of Justice and our State Council, because we also have these institutions. So international law of human rights became an integral part of Colombian constitutionalism through two different distinctive ways that have augmented the tools, the resources, the normative resources for the judges, for the domestic judges to protect human rights. These institutions are the block of constitutionality and the control of conventionality that I'm about to explain. The block of constitutionality actually comes from France, originally. It comes from an old jurisprudence. First, it was the bloc de légalité, and then le bloc de constitutionnalité. In the French context, what it did is bring back to life the old constitutions, the old charters of human rights of France into the actual constitutional frame to guarantee the protection of human rights. In the Colombian context, it has a slightly different interpretation, not only in the Colombian context, because this is a Latin American construction. The block, our block of constitutionality, is made not to integrate all constitutions into our new constitution, but to integrate international law into our constitutions. So this, of course, as I said, has widened the resources for the judges. And in the case of the Constitutional Court, that was the one that invented or adopted this institution, it means that the Constitutional Court exercised the control of constitutionality from international agreements ratified by Colombia directly. And due to the soft version of the block of constitutionality, it can also interpret the Constitution, not just interpret the Constitution under the light of the international law of human rights. Now we also have our control of conventionality that I believe is much stronger than the European one, despite that our Inter-American Court of Human Rights is very poor compared to what is the European Court of Human Rights in terms of money. Actually, our court is basically sponsored by the German government and by the German cooperation organization, GIZ and Konrad Adenauer Stiftung, and so they are the ones that sponsor our court. So despite that, the limitations, and due to the urgent necessities of the region that are much greater than the Europeans have a very acceptable level of guarantee of human rights. On the contrary, our system of human rights came to life in a very adverse situation of dictatorship and massive violations of human rights. So it really came as maybe the only hope in our legal view to fix this kind of problems. So, but moreover, so this control of conventionality that was adopted by the Inter-American Court of Human Rights, invented by the Inter-American Court of Human Rights, has been as ambitious as declaring unconventional. The constitutional norms has gone as far as declaring as unconventional constitutional norms of our countries. For example, Chilean constitution, an article of the Chilean constitution in the case La Última Tentación de Cristo was declared unconventional, and the convention and the court ordered Chile to reform the constitution on this matter. That was, of course, this has been a growing process of legitimacy of the court. It has grown in authority little by little, but these decisions have been like pushing forward the system. In the most recent times, this control of conventionality came to be mostly expressed in the diffuse version of the control of conventionality, which is that the court, the Inter-American Court, said that all of the judges and authorities of our countries should apply the convention directly. And in the case that local disposition would be found contrary to the convention, the judges and the authorities should not comply with this norm. So this is like a very ambitious thing. The problem is that just the declarations of the court are not enough, right? So this is why in our region we have we use this terminology, the jurisprudential dialogue. So what is happening now is that our Inter-American Court of Human Rights and the domestic courts or domestic high courts are in a constant dialogue in a scenarios just like this. Also, there's a very strong tradition that, at least in the case of Colombia, because the countries do have a say in the composition of the international courts. Most of the judges of the Inter-American Court that have been of Colombian nationality have usually come from the Constitutional Court itself. So this has created a phenomenon that the constitutional judges, they kind of like know there's a possibility that one day they're going to be either commissioners in the Inter-American Commission or judges in the Inter-American Court. Just at this moment, in the Inter-American Court of Human Rights, there's Justice Sierra Porto. He used to be president of the Constitutional Court. He was actually the guy that turned down Uribe. And in the American Commission, there's Luis Ernesto Vargas Silva that also participated in this decision, and he is a commissioner now. But this has been a dynamic process. The Constitutional Court was the first enthusiast in applying this block of constitutionality, but then later it became more shy about it, and in a later stage it says that the control of conventionality is to be done by the court, but in its own terms. So it kind of like domesticated what the Inter-American Court of Human Rights is, and just put the decisions of the Inter-American system, of the Inter-American Court, as a parameter for interpretation, which is not what the control of conventionality is. So this really reduced the hopes for the process of internationalization on my country. So this is what I call the domesticalization, to say it in one way. However, the State Council, that is, thanks to my friend, you already know what a State Council is, decided it's a close of culture, or it's a court of closure, so it doesn't really, it's not really below the Constitutional Court. It decided to apply the control of conventionality in the exact terms of the Inter-American Convention, of the jurisprudence of the Inter-American Court of Human Rights. So it became a third actor in the process of internationalization, and now is the leader of this process. And it did it in a very interesting way that our friend Professor Roa called the deferential way, which means that the State Council consults to the saying of the Inter-American Court at the same time as consults the presidents of the Constitutional Court. It tries to find a way to conciliate legal systems that are usually fighting each other. This is also treated by German author Armin von Bogdandi. He has this creation of the Jus Communi Constitutionale Interamericanum, which is a construction that is not only based on the centralized authority of the Convention, but a much wider construction based on the clauses of aperture of Vogel and the structure of open state that conceptualized Hans Peters. So I'm gonna try to show you how all of this applies in one specific case, just a very recent case this year, that is called, I'm going to call the Petro case. Gustavo Petro was the former mayor of Bogota and was the second candidate, almost president of Colombia in just the last elections. Petro was mayor of Bogota at the time, and the General Prosecutor's Office, that disciplinary investigations, removed him from office without judicial process. This is against the Article 23 of the American Convention. So the State Council decided that this decision was deemed unlawful in exercise of the control of conventionality and interpreted the Constitution in a totally different way than it was being interpreted to grant the efficacy of the Convention. So to close up, I have to say that many states and many judiciaries see the international law of human rights and the international courts as a threat to sovereignty or to judicial independence, but it's not like this. It's just an expansion of the resources in the goal that we all have in common, that is the protection of human dignity. So for this, jurisprudential dialogue, pluralism, post-nationalism, different approaches that are not necessarily so strict in the way they behave, can be a very useful solution, especially if we adopt a wide dialogue between judges. So thank you very much.
Thank you very much, Mr. Juan Sebastian Rodriguez. It's very inspiring in terms that group of individuals in Colombia are now having more terms of legitimate expectations toward their human rights protections in Colombia due to the applications of Inter-American Conventions of Human Rights. So I think it is the growing and also good practices towards better protections of human rights. To deals and also to give a response to your presentations, may I invite Mr. Bisariadi to give your opinions towards this topic. Mr. Bisariadi, please.
Thank you, Pak Jakarta, and also thank you, Pak Rodriguez. I've read your paper with a great interest because in Indonesia we don't have these institutions to talk about constitutionality and control of conventionalities. As I understand from your explanations that it is transferring from other legal systems which is France. I was wondering if someday there was some sort of discussions that Indonesia will probably benefit if we try to translate this same models about law of constitutionalities or control of conventionalities. Would it be best if we look from the Colombian perspective, which is already being modified, or we look from the origin, from France models? These questions arise from my probably some sort of suggestions to your paper, since it seems like you're aiming to have a wider audience from your papers. You trying to reach publications in Indonesia, which we don't have this type of knowledge. So I think it will be best for this paper if something briefly explain about how the Indonesian could benefit from this model and probably learn from the Colombian. That's my point. Thank you.
Thank you very much, Mr. Bisariadi. So I think it's inspiring the Indonesians towards our future developments, Mr. Juan. Could you please respond to Mr. Bisariadi? And ladies and gentlemen, may I remind that Pak means Mr. Mbak means Miss, and Ibu means Mother. Yeah, my apology for that. Yeah. Mr. Juan.
Thank you, Professor Bisariadi.
Okay. Oh, no problem.
Sorry.
I'm sorry. I would love to be professor. So, of course, once I got here, I noticed that I'm not a comparativist, and I don't even think I'm good at it. It's just being very humble as I was trying to look at the Indonesian law, and it seemed like a very difficult task. And I couldn't cover it in such a short time, but certainly I will, now inspired by the professors that I've met today, very excellent comparativists. I see the high virtues. The reason I chose this topic because I thought, despite not being comparative law, it could be something, as you said, something that can be copied by others. I understand there's a commission in Southeast Asia, and I understand there's the idea of trying to make something like this. So yes, of course, I'm on my way to that. Thank you so much. And between the European and the American system, well, they are quite different due to the problematics. I think that the American system can be recommended for you because the European tradition roots from a perspective of high level of integration. I know that the European Court of Human Rights does not belong to the European Union, but we have to say that European countries have a high level of integration in many ways. So, and they are they don't have the same problems as Southeast Asia can have and Colombia. We have more urgent problems, as I said. So what I think is that you should use the Inter-American model when it comes to the jurisprudential dialogue. So the latest trend that is, that as I was talking yesterday, to find a way in which the decisions of the courts are not so disrespectful to the national courts, so that the national courts can voluntarily apply them. This is something that is not necessarily happening in Europe. In the case of Spain, just a couple of years ago, the court ordered the liberation of a lot of terrorists of ETA because there was some irregularities of the laws that were holding them in prison. So at one point they were freeing ETA terrorists, and of course the Spanish government was angry at it. And then there was not this dialogue to conciliate between the international and the domestic, and this dialogue to bring together something that is so far away from each other, it is very important. So,
thank you very much, Mr. Juan. ETA, what stands for?
It's a terrorist organization that in Spain.
But my apology. So, ladies and gentlemen, speakers, may I invite for the next session for 3 questions. All right, Mrs. Sonia and then Mr. Sanya. Mrs. Sanya and Mrs. Sonia. Mrs. Sanya.
Sanya. No, I give the floor to my colleague. Yes, I will give just a short question, which Mrs. Devi can answer too, because I didn't succeed to give the question. And Juan, in the last 1 year in the region of the Balkan region, the ratification of the Istanbul Convention of the Protection of Rights of Women Against Violence, Home Violence, Family Violence, and Children was very actual, and which was very funny for 2 states. The public reacted very aggressively in Croatia and Bulgaria, despite the fact that those 2 countries were already members of the European Union. However, in Macedonia, in my home country, this ratification of this convention went completely silently. The parliament ratified it and going to be implemented. How is the situation in Colombia, and how is the situation in Indonesia towards this ratification of this convention? Thank you.
So to be honest, and this is something I didn't mention in the paper, one of the reasons why international law is so strong in Colombia is because Colombia signs everything and doesn't really do that. This is like the truest answer to it, because since always we've been so keen on being liked by everyone, so that we're always signing, and then we see how we implement it. There's also the reality that there's a very big gap between our institutions and our laws and the actual facts of people. So there's wonderful decisions, wonderful laws, and we decide on these international agreements, but then maybe the government doesn't have the money to implement it, maybe the conflict doesn't let him implement, so there's a very big distance. But to sum it up, we just sign everything and then we ratify without much of discussion. But this is what's happening in Colombia.
Right. Thank you. And Ms. Sanya.
Thank you, Juan. It is really fascinating what the Constitutional Court of Colombia is doing in terms of the rights protection. But I think if we shifted to the topic, which is political dynamics and separation of powers broadly, I really see this paradox. Like, don't you think that whatever the Constitutional Court now is doing, it might create unexpected consequences? And it might actually undermine the separation of powers, and I will explain why. So we see this tendency in Colombia of extension of extraordinary judicial power. So they started with block, then they have created this replacement doctrine. But the question is, no one really knows what are the limits and boundaries of this expansion except for the court itself, right? And this is, for me, in future might create a biggest problem, even maybe undermine the separation of powers issue. So what is your opinion about this?
I agree partially. So one of the most ambitious things of the Constitutional Court has been deciding on decisions of other high courts. So the other high courts are very angry at the Constitutional Court. They belong to the same judicial branch, but there is already some level of this breakdown. When it comes to international law, there's Morales Antoniazzi. She talked about compensatory constitutionalism, which means that the weakness of our constitution are amended through the means of the international law. We're just very resourceful when it comes to this. I know there can be a backlash. I totally get it, and there is a backlash. Just last week, the new president, that is very conservative, just proposed to finish the Constitutional Court and the Supreme Court of Justice. The Supreme Court of Justice, he wants to finish it because he was putting in jail his senators, and the Constitutional Court, well, because of its decisions. However, the Constitutional Court now is very popular because it has been the only institution that has granted rights. So, for example, nowadays the election of a judge in the Constitutional Court is like the election of the president. Everyone is looking at it, and I don't really think Colombia will ever let the Constitutional Court to be demounted. What has happened in it is that they have infiltrated, which is also like a backlash. So they try to infiltrate it. But we do have a very good system of election of the judges of the court. All of the judges of the court are elected by the Senate. However, they are elected by the Senate by candidates sent, but three of the judges are from candidates sent by the Supreme Court of Justice, the other 3 by the State Council, and only 3 by the President. The singularity of this is that both the Supreme Court of Justice and the State Council, they have system of absolute cooptation. So they are totally isolated from any political influence. They elect themselves. So usually, the 6 judges that come from the judiciary are quite technical and not so much politicians, and the 3 of the president are the ones with the political compound. So it's not really easy to infiltrate the court, both to infiltrate it or to dismount it. So I guess, does it answer your question?
All right, thanks. Mr. Professor Hayan Kulma.
Yes, just a gentle reminder about this issue. This is related to the legal transplants. How to just a gentle reminder about this topic, because it seems to me relates to the legal transplants issues. We have experience from time to time when we transform the universal values to solve the local problems. There are so many problematic, particularly at the operative level, operative models. So, like, actually this is the same problem also in my point of view, like a statement that have been proposed by Mr. Rial Kerim from the Vice President of the Constitutional Court, which emphasized the importance of the universal values, universal language without localizing the universal contents. And we know that every country has norms that cannot be separated from the collective consciousness that create the norm, and which is inseparable from the legal postulates. The legal postulate refers to the real situations, real life of people, daily practices of people. That's become the uniqueness of community. How to transform? Like you mentioned, in Colombia, there are so many clans, there are so many groups there. How to transform the universal values that should be embodied in solving the local and uniqueness, like in the LGBT case, for example, in Indonesia, for example, rise the many problems like particular and universal human rights issues. Could you elaborate?
Thank you, Professor Hyde. So we, as most things that we have built here, is just something in the middle, or try to conciliate, in this case, between the universal and the local. Part of this conciliation between the universal and the local has been the regional. That's why regional systems are supposed to console so the universal human rights a lot of times are not taken in practice, but then the regional have courts with some powers to implement their decisions. So it's like a chain of transmission. There's like, to avoid this big gap that is between the international and the domestic. And this is why the theme of the jurisprudential dialogue and the dialogue of judges is so very important, because it breaks that distance, and the international law maybe has the right to hear what the domestic have to say. And this is why it's also very important that the judges, the domestic judges, start to appropriate international law, because then they can give their own singularities to this international law. This, of course, produces partially the efficacy of international law, but it helps to rescue as much as possible of it. When it comes to our conversation about the minorities in Colombia, it is very clear that Colombia, like this kind of pluralism that is very known in multi-level constitutionalism of Europe and stuff. When the white people came to Colombia, there were plenty of Aboriginal people with ancestral cultures. And our Constitution of 1991 was aware of this. So we gave them the right to administrate their own justice and their own laws. But of course, this justice and these laws, they come to fight eventually with the values of the Constitution. So what we do is the Constitutional Court tries to preserve as much of their personal values, while at the same time to preserve as much of the values of the Constitution. The same can be done in constitutional systems in this dialogue to international law. Thank you so much, Professor, for this question.
So, ladies and gentlemen, to end these sessions, because we have more important issues, this is the right to vote for these sessions. May I conclude for this session is that it is very challenging in terms of how incorporating international law into domestic law. By now in modern societies, that those two systems are interconnected and interchangeably used towards a better protections of human rights issues, for example, also on how to move forward for better advocacy and also adjudications in terms of those issues. And also, I think by comparing all those systems, give us a clear and also inspiring horizons of the knowledge with regards to the developments of the law in our society. And also by having these academic consultations, we also have a chance to elaborate more possible way out towards a better movement of the law itself. So by outlining those concluding remarks, may we close the sessions and have a good lunch for all of you. And we will continue for the next. And we will come back at 1:30 p.m. in these rooms, continuing our discussions with new topic with new chairs, Mr. Professor Ali Safar. Thank you very much for your kind attentions, and I will end by Indonesian's proverbs that ikan cepat ikan gabus makan ikan lele ditampar ikan pot, semakin cepat semakin bagus, nggak usah bertele-tele sehingga kita cepat dapat amplop. Thank you very much.